welcome to the Drexel interview. I'm your host, Paula Morantz-Cohn, and today our guest is Senior Vice President and General Counsel Tobey Oxholm. He's been especially busy lately helping to set up a new Drexel Law School. So we're glad to have him take time off from his busy schedule to be with us today. Tobey, welcome to the Drexel interview.
It's a pleasure to be here. Thank you for inviting me.
Good. You are Drexel's Chief Legal Counsel, and I imagine there are many challenges attached to that role.
No, it's easy.
Oh, okay. But what I'm really interested in hearing about, first of all, is what it's like to be a lawyer in a university environment. And we hear all the time about what it means to be a lawyer in other environments, but I think this is a special kind of environment. And I wonder what the challenges are to being general counsel of a university.
Well, it's interesting. I came to Drexel after 22 years of practice, 5 years in the city solicitor's office in Philadelphia and 17 as a trial lawyer in some of Philadelphia's better firms. And I thought I'd be coming to a nice, relaxed environment that's a university setting. Mm-hmm. It's been like a trial for the past 4.5, 5 years. It's been wonderful. This is a very exciting place. Yeah. Part of it comes from the fact that this is a little city. We have residents, we have issues, we have employment issues, zoning issues, tax issues, advising boards of trustees, we have student things and faculty and grants and contracts and everything. There's just so many things that are going on, and that's just what a general counsel does. A general counsel is a counselor or an advisor, and I advise the president and the chief officers and the deans and the faculty about issues that have something to do with law or contracts or agreements, things like that.
Okay, so there's tremendous variety.
It is, and it's very fast-paced, and I have a wonderful staff, and it's just a wonderful place to work.
Okay, well, great. You've had some special challenges here. In 2002, we merged with the medical school, and now we're in the process of developing a law school. And I thought we'd talk first a little bit about the medical school. You were involved in that merger with Hahnemann, and one of the things you did that you've implemented that I think is exciting, and it goes beyond Drexel per se, is the development of a medical malpractice mediation program, which strikes me as a revolutionary idea. My husband happens to be a physician, so I know one side of the situation from the point of view how difficult it is for doctors dealing with malpractice and insurance rates going up and so forth. And I also know, having many friends who have been patients, the problems on the other end, where, worrying about negligence and malpractice and so forth. Tell us a little bit about this program, medical mediation program, and what you think the future of it is.
The origins of the medical malpractice program that we're running at Drexel Med, which is really is quite a remarkable program. Many people have attributed to the healthcare crisis and insurance rates and things like that. But in fact, it came from a different motivator. I was a trial lawyer, but I'd never done medical malpractice. I didn't work with doctors that way. And one of the first cases I went to involved a doctor from the medical school. And it came up very interestingly. It was the night before the trial was to start. Trial started on Monday. It was Sunday night. I got a call from the defense lawyer, who is a first-class lawyer in Philadelphia. And he says, "We have a problem." I said, "What's the problem?" He says, "The doctor now wants to say something new." Well, that's always a worry.
Yeah.
What the doctor wanted to say was that he was sorry.
Really?
It had been 6 years since what had happened, and this doctor had gotten good advice from his insurance company and from his lawyer that he should let the lawyer speak, that the doctor should always answer the questions that were given to him. Good legal advice. This is how lawyers always counsel their clients, but had never been able to talk to the family about what had happened to the man who had passed. And so the first time he was able to talk to the family after this had happened was at the trial. And the doctor was devastated, and he cried. And he said, "I am so very sorry for what happened to your husband. I haven't stopped thinking about this for 6 years." And it was tragic. And I vowed at that point that that would never again happen to any one of my doctors.
That they would be allowed to say they were sorry at an earlier point.
That they'd have to not be able to express how they felt about something that had happened. This was ripping this doctor apart. And yet he was the second victim of this.
But it does go against the standard legal protocol. How do you arrange
Well, think of it this way.
this?
When you're in an auto accident you know what you do. You have a little card from your insurance company that says, give the information about your insurance. If you say anything more than that, you may lose your insurance, so don't say anything at all.
Right.
It's the same thing they say on TV. Don't say anything because whatever you say can and will be used against you in a court of law.
Right.
Doctors would be silly to risk that. But it's against what doctors are taught. They're taught to be communicative. The patients come to them with a problem. They share everything that's wrong with them because they want to have the doctor to respond to and help cure them. When something goes wrong, the worst thing you can do to a patient is get the doctor out of the room. That's abandonment. It's no wonder juries are angry at doctors when that happens. So the first thing we decided was we have to get our doctors and patients to continue to talk to each other. It's the only way the healing relationship can continue. Mediation comes from that.
Yeah.
It says, stop fighting in court. Stop doing interrogatories and document requests and motions for this and hearings on that. Get the people in the room, the doctors, the patients, the family, and have them talk to each other. Have the doctor explain what went wrong. Have the patient be able to explain how they feel. Figure out what the family really needs. Let them understand that the doctor just didn't move on to the next case or go down to the shore in his BMW, but he brought in experts to figure out what happened, that the doctors talked about it at their M&M conferences, that they really worried about this, and they may have even changed procedures because of it. That kind of information never gets passed to the family. It does in mediation.
And what have been the results of this? How has it been implemented, and what have been the results?
Well, we started it in February of 2003. So here it is, quite a while later. 2004, excuse me, February 2004. So it's coming up on the second anniversary. It took us a very long time to get to our first mediation because we had to explain this to other defendants, other doctors, their lawyers, the insurance companies, the government insurance program. We had to get them all to agree because mediation's a voluntary process. You only go if everyone's willing to go. So it took us about 4 or 5 months to get to the first one. Now we've had about 22. And out of the 22, we've reached settlements in 17, 18. There are a couple that are still in progress. 3 did not settle. They ended up going to court, and we won. We got defense verdicts.
Yeah.
We did very well. The result of that is that our doctors know that we're not just saying, all right, we're going to pay whenever. You go to mediation means you're going to pay. We don't always pay. Sometimes we talk, and that's the end of it because the patients then understand what happened.
Right.
If it doesn't settle, we go to court, and if we go to court, we're going to win. That's our pledge to our doctors, that we will always defend you. So for us, it works. It's much better, and it's much faster for the patients and their families because they get to reach closure much more quickly.
Right.
What's wrong with that?
And they feel better.
They feel much better.
Right.
They have the opportunity to express how they feel.
Yeah.
They get closure on the situation. They can talk about what they need as a family, and if they need attention at home with more child care or things because the mother's no longer around or the father's not available because he's incapacitated or something tragic has happened, you address what the family needs at the time they need it, not 5 years later when all that can happen is a jury can say you're guilty or you're not guilty and here's how much we can pay for you. The money's not going to do it.
Right.
That's just not everything there is.
Now it seems like common sense. Why has it taken so long? And now that you have this model, to what extent is it being adopted elsewhere that you know of?
Well, this model is not unique to medical malpractice. It's new in medical malpractice, but it's actually been used in other situations. For example, wherever you have a continuing relationship, employer-employee, you can have an employee who's really angry, and they can file a grievance, they can file a lawsuit, they can still be employed. Imagine working with that for 2 or 3 years. That's a terrible situation.
Yeah.
So in the employment situation, mediation is a growing field as well. More and more lawyers, more and more insurance companies have really come to understand it in the employment context where it can work.
Right.
And people can either move on, move out and separate, or they can resolve things and continue on together inside the employer's unit again. Same thing's happening with medical malpractice. It's very small. It's only being tried, I think, in 2 or 3 places in Pennsylvania, and not that many in the United States. But what we're learning is that this is adaptable in almost any large practice group, which we are. College of Medicine is only doctors and nurse midwives. We don't have a hospital.
Yeah.
But it also works in hospital settings where they can be the focus of the attention. And that's where it started in Chicago, was with a hospital group.
Well, it sounds very exciting.
And we're teaching all around the area, and we're happy to be teaching other people because it really does work.
Yeah.
It's better for everybody. It's a very moral system.
Yeah. I wonder if you want to address any other, briefly, because I would like to get to the law school, but any other special challenges or achievements that have come as a result of this merger with Hahnemann and the fact that we now at Drexel have a medical school, which is really, quite an amazing thing when you think about it. For so many years, we were first a technological institute, then a university, and now, of course, we have a medical school.
Well, a lot of things have come out of it, including the law school, quite frankly.
The law school, you feel, is a kind of spin-off
from
having a medical school?
Unquestionably is. One of the first synergies that we had was in the biotech area. We have at Drexel Med some incredibly state-of-the-art doctors who are working with robotics and microsurgery and things I really don't understand. It's beyond my abilities to understand how it can be done. And they're very creative, and they're relying more and more on engineers to put together the medical devices that are at the frontiers of medicine. Well, Drexel's working on that on the other side of the river.
Yeah.
So we have the engineering on one side and the medical on the other. And the first thing that happened as a result of the merger between the two, the academic merger, was that these two started talking. So biotech is really an incredible area for us, and it is for our region as well. This is great things for southeastern Pennsylvania, for this part of the United States. This is a hotbed of biotech. And so that's the future of employment for our region. So we are educating our students. We're using our research to help nationally and internationally. And our faculty are well engaged and working together. It's a great result of the merger between the two.
Okay. Well, let's switch to the law school now. I mean, I think that's very exciting. And I think what's particularly interesting is the idea of starting a law school from scratch, as we are saying we're doing, and also a law school that's going to be, in some ways, different, new, that will be specific to our particular profile as a technological entrepreneurial university, but also new, I think, in the sense of maybe thinking differently about legal education. And I wonder if you would tell us about this newness, the new aspect of this law school that's in the works.
It's both new and old. Law, I went to law school, came out in 1979, so it's been a long time since I've actually sat in a law school. I've taught a couple classes, but I haven't been back much. But in the 25 years that I've been out, legal education hasn't changed all that much. Look at the medical side. How do doctors get educated? They have a couple years in the classroom, then they go and they do internships, and they follow doctors around, and they learn how doctoring is done, and they see patients and they watch at the elbows of a skilled physician or a nurse midwife. And then they specialize in an area, whether it's internal medicine or radiology, whatever their interests might be. So they specialize. And they come out at the end of that educational process, not only understanding what doctors do, but having done it. So when they actually see their patients, the first time they have their own patients, they won't have put their hands on the body the first time. They won't have asked the questions the first time. They won't have had to go in the books or prescribe medications the first time. They won't have wrestled with the right approaches the first time. Now think about how law has been handled. You go to law school, and what do law schools teach you? They teach you how to think like a lawyer. Would you go to a doctor who knew how to think like a doctor for medical care? Of course you wouldn't. So why are we producing lawyers who know how to think like lawyers, but who have never held a contract, have never ever involved themselves in an administrative agency, have never been in a courtroom, have never drafted a will or discussed with a client the different strategies that you can do in trying to transfer your wealth from your grandparents to their grandchildren? Why would you ever go to a lawyer who had never done those things? Why would a law firm hire any of those people? And these days, when I came out in 1979, I was privileged to work in a large firm, and we had 1,700 billable hours a year, and you can do the math at home and find out how much time that is per week you have to bill. But they would spend time working with us and going through drafts and taking us to real estate closings or appellate arguments or client meetings, or we'd go work with them on the boards of the ballet or legal services to helping poor people. Today, the number of billable hours is 2,000 billable hours a year or more, and you don't have time to do free legal services for the poor or go to closings or do any of the things that professionals do. The law firms are expecting the law schools to have trained the law students.